by the Governor of Nyamira County on the threshold applied for the proposed removal from office by impeachment of the Governor of Nyamira County. Oh, sorry. Allow me to take it again, Mr. Speaker. This is notice of motion for preliminary objection by the Governor of Nyamira County on the threshold applied for the proposed removal from office by impeachment of the Governor of Nyamira County by the County Assembly. Aware that pursuant to Article 181 of the Constitution and Section 33 of the County Governments Act 2012, on Tuesday the 25th of November 2025, the County Assembly of Nyamira approved a motion for the removal from office by impeachment of Honorable Amos Nyaribo, the Governor of Nyamira County, noting that by letter reference SPK/CAN/1/2025 dated 25th November 2025 and received in the office of the Speaker of the Senate on the 26th of November 2025, the Senate of the approval of the motion by the County Assembly and further forwarded to the Speaker of the Senate documents in evidence of the proceedings of the Assembly, including the list of the 23 members of the County Assembly that voted in favor of the removal from office by impeachment of Governor of Nyamira County. Further noting that one of the preliminary objections raised by Honorable Amos Nyaribo, the Governor of Nyaribo County, was a requisite what did I say? Sorry, Nyamira County. Nyamira County was a requisite threshold for passage of a motion for the removal of governor from office by impeachment, being 2/3 of the members of the County Assembly, as provided for in Section 33 of the County Governments Act and Standing Order 62 of the Standing Orders of the County Assembly of Nyamira, is 24 members of the County Assembly and was not met. Now, therefore, the Senate resolves to uphold the preliminary objection that the threshold required for the removal of a governor from office by impeachment contemplated in Section 33 of the County Governments Act and Standing Order number 62 of the County Assembly of Nyamira was not met, and forthwith terminates the hearing of the proposed removal from office by impeachment of Honorable Amos Nyaribo, the Governor of Nyamira County.
Next order.
Order number 3, motion, preliminary objection by the Governor of Nyamira County on the threshold applied for the proposed removal from office by impeachment of the Governor of Nyamira County by the County Assembly.
Senate Majority Leader.
Mr. Speaker, I rise to move the following motion. This is a preliminary objection by the Governor of Nyamira County on the threshold applied for the proposed removal from office by impeachment of the Governor of Nyamira County by the County Assembly. That, aware that pursuant to Article 181 of the Constitution and Section 33 of the County Governments Act 2012, on Tuesday, the 25th of November 2025, the County Assembly of Nyamira approved a motion for the removal from office by impeachment of Honorable Amos Nyaribo, the Governor of Nyamira County, noting that by letter reference SPK/CAN/1/2025, dated 25th November 2025, and received in the office of the Speaker of the Senate on the 26th of November 2025, the Speaker of the County Assembly of Nyamira informed the Speaker of the Senate of the approval of the motion by the County Assembly and further forwarded to the Speaker of the Senate documents in evidence of the proceedings of the Assembly, including the list of 23 members of the County Assembly that voted in favor of the removal from office by impeachment of the Governor of Nyamira County, further noting that one of the preliminary objections raised by Honorable Amos Nyaribo, the Governor of Nyamira County, was a requisite threshold for passage of a motion for the removal of a governor from office by impeachment, being 2/3 of the members of the County Assembly, as provided for in Section 33 of the County Governments Act and Standing Order 62 of the Standing Orders of the County Assembly of Nyamira, is 24 of the members of the County Assembly and was not met. Now, therefore, the Senate resolves to uphold the preliminary objection that the threshold required for removal of a governor from office by impeachment contemplated in Section 33 of the County Governments Act and Standing Order number 62 of the County Assembly of Nyamira was not met, and forthwith terminates the hearing on the proceedings on the proposed removal from office by impeachment of Honorable Amos Nyaribo, the Governor of Nyamira County. Mr. Speaker, let me first take time to explain what this motion means. We must celebrate the Senate for how refined our process have become over time. Previously, Mr. Speaker, when we have been faced before this session, by previously I mean before this current Senate, the 13th Parliament, we previously had similar situations where a county assembly will come before the Senate and they'd argue that we have impeached our governor and therefore proceed and listen to this case. And the previous ruling that had been given by the office of the Speaker, which many of us disagreed with and felt was a great travesty of justice, the greatest that has ever happened on the floor of this House, was a ruling that was made back then that an impeachment process ends at the Assembly, and what the Senate needs to look at is a case and the material of it, then make a determination whether that case, whether a case has been made for the impeachment of that governor or not. However, in this present session of the Senate, we have since evolved and refined our processes better to a point where when there is a preliminary objection, the House makes a decision first, which is a good thing, Mr. Speaker, because I believe that with the coming of age of our county assemblies, together with us here in the Senate, we must continue to make the case that there is no alternative to the law. The law is the law, Mr. Speaker. We may not agree with it. It may not be in our favor today, but it is that which binds us and keeps us as a civil society. Anything in the absence of the law, Mr. Speaker, is anarchy. And in the rule of the jungle, it favors nobody. Those in power today or those that don't find the favor of the powers that be. And therefore, we must continue to make the case that in looking into the proceedings such as this, we must first satisfy ourselves as a House of the Senate that the process and the procedure went in tandem as ascribed and prescribed in law, Mr. Speaker. Section 33 of the County Governments Act, you'd believe that a plain reading of that section of the law, Mr. Speaker, is something that everybody can easily interpret. In fact, earlier today, while listening to the proceedings, Mr. Speaker, I walked over to the clerk and asked them that what happened to what we used to have back then called the Legislative Summit. I remember attending it 2016 and the subsequent years because it used to provide a very good forum for exchange of ideas on procedure and processes between the Senate and the 47 county assemblies, Mr. Speaker. Because looking at this case, looking at the case of the two impeachments by Cheruyot, looking at the Isiolo case, it is clear, Mr. Speaker, that there is need for this House, as a House that protects the interests of county governments, must set in law the procedure and make it black and white clear to our colleagues from the county assembly of what is it that the Senate considers to be a foolproof process of the impeachment of a county governor, which when you undertake and you bring it here, we go straight to the process of listening to what your dispute is. Therefore, Mr. Speaker, this is not to tell the people of Nyamira through their representatives that there are no issues in Nyamira. There might be issues, and indeed, listening, because I happen to come from the region, and I know that there are many things. Remember, Mr. Speaker, in this House, we've entertained and even listened and tried to reconcile two factions of the same county assembly that were sitting in separate parts of the county, Mr. Speaker. That tells you that there is a problem in that county. But before we get there, Mr. Speaker, we unfortunately must ask ourselves whether this matter is properly before us as a House. That is a question and the import of this motion. Have we been properly invited? Has the governor come through the main door, or has it been thrown in through the windows, Mr. Speaker, to get before the House of the Senate? And as a House that argues and makes the point every day that we must remind the executive, we must remind our county assemblies that we cannot make law, because that is primarily what we do in this house, and then lead the way in violation of the law, unfortunately, Mr. Speaker. And as such, Mr. Speaker, when a matter such as this appears before us, we must be satisfied that indeed there was proper procedure that has been followed. For the last 3 sessions, and this is the part that we take the blame also, you know for a fact that we have refused, and I'm very intentional about the use of the word refused, as Parliament to pass the law on the impeachment procedure. I have never seen a law as critical as this, Mr. Speaker, that has gone round in circles as has been. I can recall from, I don't know, as way back as which year, Mr. Speaker, that there has always been an attempt, but unfortunately, it never gets to the end. That means we are leaving our colleagues in the county assembly to guess and try to find their way on how to follow this procedure. These are issues, some of the issues that this motion is asking us to determine, for example, today, are matters which, if we had set out properly in an impeachment procedure bill, Mr. Speaker, then we wouldn't be debating this. By now, we'd be listening to the case by the county assembly and listening to the response from the county governor. But here we are, unfortunately, Mr. Speaker, it's our country. We must be mindful of it. We have been charged with the responsibility of ensuring that we lead this nation into a state of prosperity by ensuring that people respect the rule of law. Mathematics, Mr. Speaker, is plain and simple. You know that 12 divided by 2 is 6. And you know that if you want to get a third of that 12, Mr. Speaker, then it is 4. If you want 2/3, it is 8. And you'd imagine that in many of our county assemblies, Mr. Speaker, especially following through with the decision that this House made barely a year ago in the first impeachment proceedings against the governor of Cheruyot County, Mr. Speaker, county assemblies will be aware of the decision of this House, because this House made the decision that there is no quarter or half of a human being. That if you move on to the next, so long as it is a decimal, even if it is 0.1, then it means you go to the next, because the language of the Constitution is not less than, Mr. Speaker. That tells you it cannot be below. If it is 12 and you have 12.1, already 12, it is less than. Therefore, it cannot qualify. And it is for that reason that we have said that so long as you have a decimal beyond the 0.00, you go to the next number. That having been the case, Mr. Speaker, and if our colleagues from the County Assembly of Nyamira had taken time to read through the provisions and the ruling that this House made in that matter last year, Mr. Speaker, they will have appreciated that the requisite quorum as prescribed in law would have been 24, Mr. Speaker. The second item, which is something that I find quite strange, Mr. Speaker, that it is even in their standing orders, because that's what I had counsel for the Assembly say. And I say this a lot with tremendous respect to Advocate Katwa Kigen, because he's a senior counsel, somebody I respect, a friend of mine, Mr. Speaker, that in the County Assembly of Nyamira, their standing orders provide for an alien creature, alien to any legislature world over, has a provision called voting by proxy. I have never heard of such an animal, Mr. Speaker. Even as you know, if you follow the proceedings of this House, Mr. Speaker, before we take any vote, the sergeant at arms, after the division bell is rung, always move round to ensure that the voting booth, all the 67 of them, if it is not occupied by an individual voting, then that machine is inactive by removal of the card. That is to prevent exactly that, because it is not possible to transfer your delegated legislation role, Mr. Speaker. And it is not possible to argue and say that I was away, I was at a funeral, and I call my colleague and say, vote for me in this or another way. Mr. Speaker, I don't know. I have not taken time to read the County Assembly's standing orders of Nyamira. And if there is any other county assembly in the Republic of Kenya that has any such provisions, please delete it, because it is an illegality and there is no way that anybody can ever take you serious as a county assembly if you have such provisions in law. The parliamentary practice is as such that you vote as an individual, or if you have delegated power in the case of Senate, for example, if you're a member of a delegation and your head of delegation has given you the mandate to vote, then you can vote on their behalf as it happens. Because Senate is unique, we vote by delegations. But county assemblies vote by individual. They don't vote by delegations. And therefore, that is a second basis upon which we are being asked as a House to consider that particular matter. Therefore, Mr. Speaker, if this House agrees with this motion as moved, it basically means we have not told the County Assembly of Nyamira that you don't have a case before us. We have only told you that the case is not properly before this House. Should you go back, organize yourself, get the requisite numbers and bring it, then we shall open the file and listen to your issues. And you will not be the first that this has happened to. I'd give you the unfortunate example of my own county, that when they came here the first time, they had a similar issue on threshold. And this House sent them back. They went and did what they needed to do, Mr. Speaker. It's not to say that I'm encouraging the County Assembly of Nyamira to go back and do that which they did. That's a decision of their own, Mr. Speaker. But matters must be properly before us. As we speak today, Mr. Speaker, it still pains me when I see two governors, one of them actually Governor Mike Sonko and Governor, what was his name? Governor of Waititu. The truth of the matter, any human being knows that threshold was never achieved in those two county assemblies. In fact, if you read through the pleadings that were brought before us, it was clear and obvious. Yet this House, back then, because of the prevailing political environment in the country at that particular time, we were told in black and white that you are not the county assembly. Don't count. Just proceed and listen to the case. I am happy that at least we have refined our processes to a point that county assemblies know that we will come and check. We will have to satisfy ourselves that you followed the procedure, Mr. Speaker, before eventually making a determination. I made a request earlier on, Mr. Speaker, and perhaps this is my last point because I don't need to belabor. This is a very straight point matter. I want to make my submissions and request the counterpart leader from the minority side to second, then we can listen to our colleagues and make a determination so that if our colleagues are satisfied that those 2 points don't matter, we can proceed and listen to the case. Otherwise, if they choose to be firm and say this is the true state of the matter, Mr. Speaker, because unfortunately, colleagues, the maxim of law making is as such that you must always remember the law that you pass in the hands of your worst enemy. Colleague senators, tomorrow you can be a cabinet minister, you can be a president, a deputy president, Mr. Speaker, a governor. Will it satisfy you if you know that the procedures of our country are such that even if 5 people met and they said, we have impeached you, then the processing house will listen and say it doesn't matter? Numbers do matter, Mr. Speaker. I don't believe that it was out of lack of something useful to include in our constitutional dispensation, Mr. Speaker, that we set a threshold and a limit that must be attained before a governor comes to this House. And therefore, I convene, having said that, Mr. Speaker, the last point that I wanted to say is that I hope after this process, number one, I want to make the case that we must return the legislative summit. 1, 2, 3 county assemblies tells you that there is a problem in our county assemblies, that there is something that we don't seem to be reading from the same script. And impeachment is not just a political tool to be used on your enemy. It is a procedure of law which unfortunately you must either attain, and if you fail to attain it, Mr. Speaker, there are consequences to it. Why should we go back to the legislative summit? It is so that this House, led by a very competent technical staff, Mr. Speaker, can set out, including, Mr. Speaker, the charges that needs to be brought before us. I don't want to say a lot because I have to balance also between the things that I say, Mr. Speaker, and appearing as if I disagree completely with what the county assembly is saying. But I believe even in laying out the charges before a county governor, we must then provide the template as parliament. I think today's charges, Mr. Speaker, and I've listened to close to 20 impeachments in this House, was the longest. The charges were read for almost 30 minutes. Even the person being accused, Mr. Speaker, by the time they are rising to plead, either guilty or not, they have forgotten what the initial charges were, Mr. Speaker. We must at least do better and develop the template for that particular item, Mr. Speaker. Therefore, I don't want to say more than that. I think I have said everything that I need to say. Colleagues, the decision is yours. I want to sit and listen also. That's my perception and what I feel about this particular matter. But ultimately, the decision is yours. Remember, you're seated as a jury, and ultimately, you have to satisfy yourself before making a decision whether to proceed and now open the case or terminate it because it is not properly before us. With those many remarks, Mr. Speaker, I beg to move and request the Leader of Minority, Justice Retired Stewart Matsayo, to second this motion. I thank you, Mr. Speaker.
Asante mstahiki Spika. Mstahiki Spika, kwanza nataka kuunga mkono aliyosema yote ndugu yangu Aaron Cheruyot. Kitu cha kwanza lazima tuelewe ya kwamba huu ni mtihani mkubwa sana ambao sisi kama senators katika hili bunge lazima tuzingatie. Kitu cha kwanza ni kwamba kumwachisha kazi ama kuangalia